all of these problems that all these states are doing. It was a case called Hurtado versus California from 1887. And so, the state of California is ultimately responsible for leading the whole entire country astray right now. And so, they kind of need to accept responsibility for the fact that, states do not have the authority to substitute their own alternative legislation for the guarantees of the Constitution and then direct their agents to act in a manner contrary to what the Constitution so demands, because these agents are bound and accountable by oath or affirmation to what the Constitution dictates, and those are their obligations. And when you fail to fulfill an obligation, that is also known as a crime. So, we need to make sure that they understand that these are crimes that are being committed, that an agent of government has an obligation by oath or affirmation when they enter into their office that they will do what the Constitution of the United States says, particularly judges and prosecutors. And, those are obligations, right? Obligations. And so an obligation can be seen from two different perspectives. From the one bound, the obligation is a duty. From the one entitled, the obligation is a right. So when you have an obligation, right, then that means that you have a duty to act. And of course, when you breach a duty to act or fail to do it willfully or negligently, that is a crime. That's the crime that we're dealing with. Because remember, any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution commits the crime of deprivation of rights under color of law. So, no public official can fail to fulfill the obligations that they have. Someone asked a question earlier about jurisdiction, because I just posted a jurisdiction video. You guys were able to see it, and they said, well, if there's an obligation for them to hear it, for the Supreme Court of the United States to hear a case as the court of original jurisdiction, then does that mean that they can use their discretion to not hear it? And the answer is no, you guys. You cannot abuse your discretionary authority to breach a constitutional obligation, because that would be abuse of discretion, right? And that's upheld in a lot of different places, right? That's upheld in statute. That's upheld it's in a lot of different places. Okay, so abuse of discretion. If you want to find out what abuse of discretion is, which is what happens when you abuse your discretionary authority to disregard an obligation or breach a constitutional obligation, then you would go to the Circuit Court Handbook, right? The Circuit Court Handbook describes the two-part test that is used to determine abuse of discretion. Now, it says that the first part of the test is, did the judge render a decision that he apply an incorrect test? And, in the case of a child, for instance. So there's 4 levels of judicial test, 4 levels. The highest is known as strict scrutiny, which requires the compelling state interest test. And that means that basically, yes, you have to go out and prove that there's nothing else that you could do but deprive this person of this right. Every single fundamental right requires strict scrutiny, compelling state interest test, the highest judicial test. Now, the reason why they have to prove to someone else that there's nothing else they can do is because when it comes to a federal constitutional right, a state cannot breach or take away a federal constitutional right, because if they do, that's a federal issue. And we know every single day that they tell us, oh, that's a state issue, go back and argue with the state, right? That's a state issue. And so, there's a separation of powers. There's state issues, there's federal issues, but the federal Constitution resides outside of the state's limited or statutory governing limits. So when a state chooses to exceed the power authority that statutorily conferred upon it by the Constitution and breach a federal right, that's not a state issue, that's a federal issue. So at the end of the day, they have to use the highest judicial test. Now, the lowest judicial test is what's called the discretionary test. A judge can never, ever, ever use discretion in order to abridge a constitutional right, because that's a constitutional obligation. It's a duty that they have to ensure, protect, and preserve it. So Constitutional Law 171 says state courts and federal courts are equally obligated to guard and enforce every single right secured by the Constitution. So if the Constitution says that you have the right to have an intimate association with your child without governmental interference, that's the obligation of the judge. He has an obligation to preserve and protect that right. And if he doesn't, then guess what? He has abused his discretionary authority by applying the incorrect judicial test. And according to the Circuit Court Handbook, any time that the judge applies the incorrect test, that would be an abuse of discretion. Now, the second part of the test is any erroneous view of the law is an automatic abuse of discretion. Now, an erroneous view of the law, for instance, would be that in the judge's legal contemplation, that the inferior state statute that permits him to abridge a constitutional violation is in legal contemplation spirit to the guarantees and protections of the United States Constitution. That would be an obvious erroneous view of the law. The highest form of law is the supreme law of the land, the Constitution of the United States. Therefore, when you rely upon an inferior law that permits you to abridge a guarantee of the Constitution of the United States, that would be an erroneous view of the law. Therefore, an automatic abuse of discretion has occurred. And according to Blackstone, anytime that there's an abuse of discretion, there's 3 crimes that automatically occur. Automatically. One is extortion, because they are compelling a result through illegal means, right? So they're abusing their discretion in order to take away a right guaranteed by the Constitution. So they're compelling a result through illegal means. The second is perjury, because they are failing to fulfill the promise that they made, right, upon entering into their office by oath or affirmation. They're failing to fulfill the promise, and you have already implicitly invited punishment in the form of perjury should you fail to fulfill that promise. So, so then the third crime is oppression. Oppression is when you apply the law unequally amongst different members of society. So when the judge makes a decision that he's going to permit this person to continue to have a relationship without governmental interference of their children, but not this person, that would be a person in a position of authority applying the law unequally amongst our society, which is the crime of oppression. So those 3 crimes are automatic. They're per se as a result of any abuse of discretion by any public official vested in law.
There are more people serving life sentences today in our prisons than there were serving any sentence in 1970. So 1 out of 47 Americans is subject to some form of correctional supervision today.